Yeah, right, mate. Welcome back again. Today we'll discuss another important issue of EU law, namely the primacy of EU law. Once again, let's travel back in time to the beginning of the 1960s. By law number 1643 of the 6th of December 1962 and subsequent decrees, the government of the Italian Republic nationalized the production and distribution of electric energy and created an organization called the National Electricity Agency, which is often known as ENEL. The assets of the electricity undertakings were ordered to be transferred to this ENEL agency. And now let me introduce the protagonist of our case today, Mr. Flaminio Costa. Mr. Flaminio Costa was a practicing lawyer in the beautiful city of Milano, Italy. And here I've got a picture of the Cathedral of Milan, just to give you one idea about where the case took place. Besides being a lawyer, Mr. Flaminio Costa was a proud shareholder and customer of the Italian electricity company Disinvolta. When he heard that the Italian government adopted a new law with a view to nationalizing his beloved electricity company Disinvolta, Mr. Costa was furious, and he was determined to throw a spanner in the works. And Mr. Costa wanted to do everything he could to stop the arbitrary nationalization process. So Mr. Costa thought through a plan, and he waited patiently until he received an invoice from the National Electricity Agency, ENEL. After several weeks of waiting, he finally received an invoice from the National Electricity Agency, ENEL. The amount of the invoice was 1,925 Italian lira. To give you one impression of how much money it was, so when Italy and 11 other EU countries adopted the euro on the 1st of January 2002, the official exchange rate was €1 for 1,936 Italian lira. Despite the inflation over a period of 40 years, you may agree with me that the amount of the invoice that Mr. Costa received was a quite small amount. Anyhow, for Mr. Costa, this was a fundamental issue. Therefore, Mr. Costa initiated a legal proceeding with the Giudice Conciliatore of the City of Milan, which can be compared to a county court in England and Wales, or a Kantonrechter in the Netherlands. Mr. Costa argued that the nationalization of his electricity company was not in conformity with the certain provisions of the EEC Treaty and therefore invalid. As a result, the National Electricity Company did not validly become a contracting party to his electricity supply agreement. Thus, the invoice was unjustified and unfounded. So this was the argument presented by Mr. Costa. Meanwhile, Mr. Costa asked the Giudice Conciliatore to refer this case to the European Court and to ask the European Court to give it a preliminary ruling on the interpretation of certain provisions of the EEC Treaty. Nevertheless, the presiding judge of the Giudice Conciliatore refused to refer this case to the European Court. Instead, the presiding judge referred the case to the Italian Constitutional Court. On the 24th of February 1964, the Italian Constitutional Court ruled that the EEC Treaty did not enjoy a special rank in the hierarchy of legal sources. Therefore, according to the Italian Constitutional Court, the ordinary rule of a statutory interpretation granting precedence to the newer law would apply in case of a conflict. As the EEC Treaty was incorporated into Italian law in 1957, the Italian Constitutional Court ruled that the treaty could not prevail over the electricity nationalization law enacted in 1962. Anyhow, when the presiding judge of the Giudice Conciliatore refused to refer the case to the European Court, Mr. Costa quickly came up with a backup plan. After Mr. Costa received the second invoice from the National Electricity Agency, ENEL, he filed a new case with the Giudici Conciliatori, and this time he had better luck. The Giudici Conciliatori judge handling the second case was willing to refer the case to the European Court, and he did so. On the 15th of July 1964, approximately 5 months after the judgment given by the Italian Constitutional Court, the European Court gave its own judgment. The European Court says, by contrast with ordinary international treaties, the ECLI Treaty has created its own legal system, which on the entry into force of the treaty became an integral part of the legal system of the member states, and which the courts are bound to apply. By creating a community of unlimited duration, having its own institutions, its own personality, its own legal capacity, and capacity of representation on the international plane, and more particularly real powers stemming from a limitation of a sovereignty or a transfer of powers from the states to the community, the member states have limited their sovereign rights, albeit within limited fields, and have thus created a body of law which binds both their nationals and themselves. So if you have watched my previous video, this may sound very familiar to you. Yes, it exactly derives more or less from the Fangetta Laws case. Okay, then, the European Court continues and then adds, the integration into the laws of each member state of provisions which derive from the community, and more generally the terms and the spirit of the treaty, make it impossible for the states as a corollary to accord precedence to a unilateral and subsequent measure over a legal system accepted by them on the basis of reciprocity. Such a measure cannot, therefore, be inconsistent with that legal system. So here, such a measure refers to a domestic law. The executive force of community law cannot vary from one state to another in deference to subsequent domestic laws, without jeopardizing the attainment of the objectives of the treaty. Also, the court adds, the precedence of community law is also confirmed by Article 189, which is nowadays Article 288 of the TFEU, whereby a regulation shall be binding and directly applicable in all member states. And this provision, which is subject to no reservation, would be quite meaningless if a state could unilaterally nullify its effects by means of a legislative measure which could prevail over community law. So basically, the court refers to the secondary EU laws. And if you watch my first video on the sources of EU law, you may still recall that we discussed about Article 288, which gives a lovely summary of the secondary EU laws. In the Costa ENEL case, the court reiterates that it follows from all these observations that the laws stemming from the treaty are independent source of law, could not be overridden by domestic legal provisions, however framed, without being deprived of its character as a community law, and without the legal basis of the community itself being called into question. The transfer by the states from their domestic legal system to the community legal system of the rights and obligations arising under the treaty carries with it a permanent limitation of their sovereign rights, against which a subsequent unilateral act incompatible with the concept of the community cannot prevail. So to quickly recap, in this case, basically speaking, the European Court rules that the community law is above the national laws of a member state. In my previous video, we discussed the case of the Fangenta laws, in which the court holds that an individual can directly invoke the laws of the community in front of a national court. So together, these two landmark cases laid a solid foundation for the development of the community law and the European Union. Alright, this is what I want to share for today. If you like my video, please subscribe and give a thumbs up. Thank you very much, and hopefully see you soon. Take care. Bye-bye.